Michigan Real Estate Contracts Practice Test. Question 1. During an advertising campaign in Dearborn, a listing licensee encounters a rule involving the handling terms for property management money. Which response follows Michigan law, while the file concerns a office condominium, a brokerage policy manual, and a property minus management payment? Option A. Leave them to an oral understanding. Option B. Place them in the deed only. Option C. Let each tenant choose after payment. Option D. State them in the written property management employment contract. The correct answer is option D. State them in the written property management employment contract. The management agreement must address safekeeping, disbursement, use, and account treatment. A written office procedure should produce the same result in comparable transactions. A deed or tenant preference does not establish the manager's financial duties. Question 2. A property manager is preparing for a transaction minus file review in Battle Creek. Which statement correctly addresses records requested by an authorized department representative during normal business hours, while the file concerns a condominium unit, a continuing minus education certificate, and a delayed possession term? Option A. Destroy the records immediately. Option B. Require a court judgment in every case. Option C. Allow inspection of reasonably necessary documents and records. Option D. Provide only advertising photographs. The correct answer is option C. Allow inspection of reasonably necessary documents and records. The department may examine business records reasonably connected to an investigation or regulatory review. In the described setting, the brokerage should document the step and apply it before moving forward. The inspection authority is broader than a request for promotional materials alone. Question 3. Which Michigan requirement should control when a new applicant deals with a licensee selling property in which the licensee has an ownership interest during a closing preparation, while the file concerns a retail suite, a closing statement, and a cooperating brokerage? Option A. Disclose the ownership interest and licensure in writing before an offer is signed. Option B. Disclose only after closing. Option C. Conceal the interest if the price is fair. Option D. Tell only the lender orally. The correct answer is option A. Disclose the ownership interest and licensure in writing before an offer is signed. A buyer must receive advance written notice when the seller is also a real estate licensee with an interest in the property. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Fair pricing does not excuse non-disclosure. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass in payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At a team training, the brokerage discusses the purpose of a seller property condition disclosure. Which conclusion is most accurate, while the file concerns a manufactured home site, a fair minus housing complaint record, and a rejected counteroffer? Option A. Replace the buyer's inspection. Option B. Transfer title to the buyer. Option C. Guarantee the property will never need repairs. Option D. Provide the buyer with required information about known property conditions. The correct answer is option D. Provide the buyer with required information about known property conditions. A statutory condition statement communicates the seller's knowledge about covered aspects of the property. For exam purposes, focus on the regulated relationship rather than an informal business custom. The document neither substitutes for due diligence nor conveys ownership. Question 5. A compliance question in Kalamazoo concerns a known material defect that affects a purchaser's decision. Which action or statement is appropriate, while the file concerns a 2-unit rental, a brokerage policy manual, and an assumed business name? Option A. Remove it from every transaction file. Option B. Communicate the material information as required rather than conceal it. Option C. Hide it until after possession. Option D. Describe it as confidential pricing data. The correct answer is option B. Communicate the material information as required rather than conceal it. Material property information can affect value, safety, or a reasonable buyer's decision. The transaction context changes the facts, but it does not change the underlying licensing duty. Deleting the fact from a file does not remove the underlying duty. Question 6. How should a Michigan licensee handle a situation involving a seller disclosure form compared with a professional inspection, while the file concerns a historic residence, a continuing minus education certificate, and a security minus deposit question? Option A. The form is an appraisal. Option B. The form makes all contingencies void. Option C. The disclosure does not replace an independent inspection. Option D. The form guarantees structural soundness. The correct answer is option C. The disclosure does not replace an independent inspection. The seller statement reports knowledge rather than providing a complete technical evaluation. A written office procedure should produce the same result in comparable transactions. Appraisal and contingency rights serve different purposes. Question 7. Which choice best applies the state rule concerning refusing housing minus related service because of a protected characteristic to a seller consultation, while the file concerns a student rental, a closing statement, and a dual minus representation concern? Option A. A lawful appraisal adjustment. Option B. Permitted client screening. Option C. Unlawful discrimination. Option D. A required agency disclosure. The correct answer is option C. Unlawful discrimination. Housing opportunities must not be restricted on a prohibited discriminatory basis. In the described setting, the brokerage should document the step and apply it before moving forward. Agency paperwork or valuation methods do not justify unequal treatment. Question 8. A file from Pontiac raises an issue about directing buyers toward or away from neighborhoods based on protected characteristics. Which answer identifies the governing requirement, while the file concerns a vacant commercial parcel, a fair minus housing complaint record, and a protected minus class inquiry? Option A. A lawful zoning variance. Option B. A title search. Option C. A neutral market analysis. Option D. Steering and discriminatory practice. The correct answer is option D. Steering and discriminatory practice. Neighborhood recommendations cannot be based on the protected composition of residents. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Title and zoning work do not authorize discriminatory channeling. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a buyer consultation, which rule should the employing broker apply to advertising that indicates a preference or limitation based on a protected status, while the file concerns an industrial site, a brokerage policy manual, and a disputed repair credit? Option A. A lawful deed restriction. Option B. A discriminatory advertising. Option C. A required broker identifier. Option D. Permitted puffery. The correct answer is option B. Discriminatory advertising. Marketing language may not signal that protected people are unwelcome or preferred. For exam purposes, focus on the regulated relationship rather than an informal business custom. Broker identification and ordinary promotional opinion are separate issues. Question 10. A Michigan exam candidate reviews a scenario involving reasonable accommodation for a person with a disability. Which option reflects the current licensing framework, while the file concerns a new construction home, a continuing minus education certificate, and an electronic signature? Option A. Consider a necessary change to rules or practices unless an applicable defense exists. Option B. Treat the request as a commission dispute. Option C. Require the person to waive civil rights. Option D. Reject every request automatically. The correct answer is option A. Consider a necessary change to rules or practices unless an applicable defense exists. Disability protections may require flexibility in policies so a person can use and enjoy housing. The transaction context changes the facts, but it does not change the underlying licensing duty. A brokerage minus fee issue does not resolve an accommodation request. Question 11. The broker's policy manual addresses fraud, deceit, or dishonesty in licensed practice. Which provision should it contain, while the file concerns a mixed minus use building, a closing statement, and a referral arrangement? Option A. An automatic contract amendment. Option B. A grounds for occupational discipline. Option C. A protected marketing strategy. Option D. A required form of negotiation. The correct answer is option B. Grounds for occupational discipline. Dishonest conduct undermines the competence and trust expected of a licensee. A written office procedure should produce the same result in comparable transactions. Negotiation does not authorize intentional deception. Question 12. A regulator asks about gross negligence or demonstrated incompetence during a brokerage review. Which response demonstrates compliance, while the file concerns a cooperative unit, a fair minus housing complaint record, and a team social minus media post? Option A. Conduct that can support disciplinary penalties. Option B. A protected advertising style. Option C. A substitute for continuing education. Option D. An exemption from supervision. The correct answer is option A. Conduct that can support disciplinary penalties. Serious carelessness and inability to perform regulated work can trigger professional sanctions. In the described setting, the brokerage should document the step and apply it before moving forward. Education and advertising rules do not convert incompetence into lawful practice. Question 13. Which statement would be safest for a new applicant to follow when false advertising by a licensee becomes relevant, while the file concerns a farm parcel, a brokerage policy manual, and a record inspection request? Option A. A disciplinary violation. Option B. A method of deed delivery. Option C. A permitted team slogan in every case. Option D. A title minus insurance requirement. The correct answer is option A. A disciplinary violation. Real estate marketing must be truthful and comply with brokerage minus identification rules. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Deed and title procedures are unrelated to advertising honesty. Question 14. A dispute arises during a renewal review over helping another person perform regulated brokerage work without a license. Which principle resolves the issue, while the file concerns a lakefront cottage, a continuing minus education certificate, and a branch minus office distance issue? Option A. A zoning enforcement function. Option B. Evading unlicensed practice. Option C. Lawful delegation to any friend. Option D. A required referral method. The correct answer is option B. Aiding unlicensed practice. A licensee may not enable an unlicensed person to perform activities reserved for licensed practitioners. For exam purposes, focus on the regulated relationship rather than an informal business custom. Calling the activity a referral does not change its substance. Question 15. In Novi, a branch manager must decide how to proceed with practicing while a license is suspended, revoked, or lapsed. Which decision is consistent with Michigan requirements, while the file concerns a townhouse, a closing statement, and a financing contingency? Option A. The license remains active for pending deals. Option B. The employer may privately reactivate it. Option C. The person is treated as unlicensed. Option D. Only advertising is prohibited. The correct answer is option C. The person is treated as unlicensed. Authority to practice depends on a current license in good standing. The transaction context changes the facts, but it does not change the underlying licensing duty. Only the department can restore lawful status through the applicable process. Question 16. Which exam answer accurately classifies the rule involving failure to comply with a final board or department order, while the file concerns a urban infill property, a fair minus housing complaint record, and an unrepresented consumer? Option A. A private contract defense. Option B. A fair minus housing exemption. Option C. A separate basis for discipline. Option D. An automatic license renewal. The correct answer is option C. A separate basis for discipline. Final regulatory orders are enforceable obligations of the licensee. A written office procedure should produce the same result in comparable transactions. Private transaction terms cannot override the order. Question 17. A new policy is being drafted for keeping a client's confidential negotiating information private. Which language belongs in the policy, while the file concerns a subdivision lot, a brokerage policy manual, and a confidential price limit? Option A. A fiduciary responsibility subject to legal disclosure exceptions. Option B. A reason to hide known hazards. Option C. A duty owed only to competitors. Option D. An optional courtesy after closing. The correct answer is option A. A fiduciary responsibility subject to legal disclosure exceptions. Agency loyalty includes protecting confidential information obtained through representation. In the described setting, the brokerage should document the step and apply it before moving forward. It cannot be used to conceal material facts that must be communicated. Question 18. During team training, the supervising broker tests knowledge of presenting offers and material transaction information promptly. Which answer should the team select, while the file concerns a rural acreage, a continuing minus education certificate, and a change of employing broker? Option A. Part of competent and loyal client service. Option B. A prohibited communication. Option C. Optional when commission is small. Option D. A task reserved for the assessor. The correct answer is option A, part of competent and loyal client service. Clients need timely information to make informed decisions about offers and risks. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. The size of compensation does not reduce professional responsibility. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain an owner selling the owner's property in an occasional transaction. Which explanation reflects Michigan law, while the file concerns a single-family residence, a closing statement, and an owner-licensee conflict? Option A. The owner becomes a broker automatically. Option B. Only a lender may sell the property. Option C. Every owner must obtain a salesperson license. Option D. An owner exemption may apply if the activity is not a principal vocation requiring broker licensure. The correct answer is option D. An owner exemption may apply if the activity is not a principal vocation requiring broker licensure. Owners may generally handle their own property, but Michigan limits commercialized patterns of owner sales. For exam purposes, focus on the regulated relationship rather than an informal business custom. Ownership alone is not an unlimited exemption from broker licensing. Question 20. Which compliance step is required when the transaction facts involve an owner completing more than 5 property sales in 12 months without using a broker, while the file concerns a small apartment building, a fair-housing complaint record, and an expired license issue? Option A. The transactions become tax-free. Option B. Only a building permit is required. Option C. The owner remains exempt without limit. Option D. The activity is treated as a principal vocation requiring broker licensure. The correct answer is option D. The activity is treated as a principal vocation requiring broker licensure. Michigan uses transaction frequency as one indicator of professional real estate sales activity. The transaction context changes the facts, but it does not change the underlying licensing duty. Tax and construction approvals do not replace occupational licensing. Question 21. A listing licensee notices a potential problem involving an owner spending more than 15 hours per week over a 6-month period selling owned real estate. Which response should occur first? While the file concerns a office condominium, a brokerage policy manual, and a property management payment? Option A. The owner is always exempt. Option B. The rule applies only to renters. Option C. The activity can be treated as a principal vocation. Option D. The time is counted only after closing. The correct answer is option C. The activity can be treated as a principal vocation. Substantial weekly work devoted to owner sales can move the activity beyond casual disposition. A written office procedure should produce the same result in comparable transactions. Closing dates and tenant status do not control this test. Question 22. The state portion of the exam presents facts about the additional pre-licensure education associated with an individual broker applicant. Which result is supported, while the file concerns a condominium unit, a continuing education certificate, and a delayed possession term? Option A. 10 hours of advertising only. Option B. 90 hours beyond salesperson education. Option C. 40 hours total including salesperson education. Option D. No additional education. The correct answer is option B. 90 hours beyond salesperson education. Broker-level preparation requires substantial coursework beyond the salesperson foundation. In the described setting, the brokerage should document the step and apply it before moving forward. The additional requirement is not satisfied by repeating only the initial salesperson total. Question 23. Which brokerage practice properly addresses a salesperson license application under the statutory employer structure in the Pontiac transaction, while the file concerns a retail suite, a closing statement, and a cooperating brokerage? Option A. The county clerk becomes the employer. Option B. A home inspector signs as sponsor. Option C. The applicant self-employs immediately. Option D. The employing broker signs or approves the affiliation required for issuance. The correct answer is option D. The employing broker signs or approves the affiliation required for issuance. The salesperson credential is issued within an employing-broker relationship. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Independent practice is not created merely by passing the examination. Question 24. A licensee is comparing 4 procedures related to a salesperson license as to legal form. Which procedure is lawful, while the file concerns a manufactured home site, a fair minus housing complaint record, and a rejected counteroffer? Option A. It belongs to the property being sold. Option B. It is issued only to an individual. Option C. It may be issued to any corporation. Option D. It is issued to a branch office. The correct answer is option B. It is issued only to an individual. Michigan treats the salesperson credential as an individual occupational license. For exam purposes, focus on the regulated relationship rather than an informal business custom. A location or parcel cannot hold a salesperson credential. Question 25. At the end of an offer review, the parties question an associate broker's status. Which statement provides the best guidance, while the file concerns a 2-unit rental, a brokerage policy manual, and an assumed business name? Option A. A salesperson with no broker qualifications. Option B. An unlicensed assistant. Option C. A broker minus qualified individual working for another real estate broker. Option D. A county recording officer. The correct answer is option C. A broker minus qualified individual working for another real estate broker. An associate broker has met broker licensing standards but practices through an employing broker. The transaction context changes the facts, but it does not change the underlying licensing duty. It is distinct from clerical assistance and ordinary salesperson status.